Okay, I think we have what we need. Your name, sir?
Langford Jackson.
Okay, thank you, sir, for your patience. We're on the record. Calling case number 2105505 People State, Michigan versus Lemford Carl Jackson, counsel.
Driver operate 3665 on behalf of Mr. Langford Jackson. Wait, reading stand. Mr. Jackson's been advised to counsel.
Oh, wait, formal reading it tonight. Guilty plea on your client's behalf. Stand by one of the things. Okay, there is a Zoom probable cause conference date set for February 1, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date to be determined, also at the 36th District Court, and this will be in front of Judge Archer and as the bond.
That's fine, Your Honor. Mr. Jackson is a lifetime resident here in the city of Detroit. He maintains that she's gainfully employed at the Cheesecake Factory. Was gainfully employed at the Cheesecake Factory, Your Honor, right now with 2 odd jobs. He has 5 children. He resides with his mom. He understands the law of court case and doesn't treat the non-assault delegation. Respectfully ask this court for a personal bond.
Thank you. Did you see his bond? Any holds?
No holds, Your Honor.
Okay, thank you. Counsel Court takes in account representations, including your client's significant ties to the community as well as family ties, and that he, up until recently, was seeking or had secured gainful employment, and also in light of the pandemic facing the nation at this time, court is going to set bond in the amount of $3,000, personal bond. Is there anything further? Okay, you're all set, so you can step away from the camera.
Step out.
All right, wait a minute, man. Someone like to say a personal last name.
Your name, sir?
Keenan Horton.
Okay, calling case number 2105505 People State, Michigan versus Keenan Horton, counsel.
Driver operate 3665 Keenan Horton. Mr. Horton is about to come to court.
Court with formal reading it tonight. Guilty plea on your client's behalf. There's a Zoom probable cause conference date February 1, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date, also by at a date to be determined at the 36th District Court in front of Judge King and Esteban.
That's why Your Honor, I'd like the court to know that Mr. Horton has absolutely no criminal history and lifetime residence here in the city of Detroit. He has gainful employment at Eagle Morris Italian Restaurant, Your Honor. We ask this court respectfully to consider a personal bond in this matter.
Thank you. And DDC's bond, any holds?
No holds, Your Honor.
Thank you, ma'am. Counsel Court takes into account representations, including your client's significant ties to the community and gainful employment, also in light of the pandemic facing the country, and this is also a non-assaultive matter. Court will set bond in the amount of $1,000, personal bond. Is there anything further? Okay, you're all set, so you can step away from the camera.
We already.
Oh, thank you.
Brandon Watts.
Okay, and I think, actually wasn't it the one that counsel wanted to zoom in on, but I know he's interviewing. So DDC, Counsel Reagan indicated that he's going to be representing Mr. Watts, but he's currently on camera 1 interviewing with the interpreter for Mr. Banks. In the meantime, can we do Mr. Cole? Hi, your name, sir?
John E. Cole.
Okay, calling case number 2105505 Peoples, Michigan versus Jami Fahim Cole, counsel.
Driver operate 3665 on behalf of Mr. Cole. What are you bringing to Mr. Cole to the advisory council?
Cole with full reading it tonight. Guilty plea on your client's behalf is a Zoom probable cause conference date February 1, 2021 at 8:30 a.m. to 36th District Court, followed by a preliminary examination date to be determined at the 36th District Court in front of Judge Giles and Esteban.
That's fine, Your Honor. I'd like the court to know that Mr. Cole is a 18-year-old lifetime resident here in the city of Detroit with absolutely no prior criminal history. The high school graduate.
Thanks. Thank you. DDC's bond, any holds?
No holds, Your Honor.
Thank you, ma'am. Counsel Court takes into account representations, including your client's significant ties to the community, although the court does have concern that your client is of a tender age and rather is not otherwise eligible with regard to the basis of some of the charges as it relates to this case. Then I would stand and given your client's significant ties and in light of COVID as an additional concern, court on this case will set bond $2,000 personal bond. Is there anything further? Okay, stand by. Mr. Sam? With this one, when you get a chance, we just need a mitt at the bottom. It has Judge Jallis's name, so it just needs to have mine on it. But otherwise, the bond is the same. This is gonna be $2,000 personal bond. You're all set, so you can step away from the camera.
Just step out.
Okay, DDC, I think for Mr. Watson, Mr. Banks, we're just waiting for counsel to come available.
Okay. Oh, yeah.
Thank you, sir. Thank you, sir.
So we got. You ready for it?
Hey, Madam Interpreter, are we ready for you? Okay, stand by. I'm going to close the break. Okay, I'm going to close all the breakout rooms. That should do it, and put everybody back. Okay, that should work. Okay, and we're ready on Mr. Banks' counsel. Is that correct?
That's correct, Judge.
Okay, thank you. Madam Interpreter, if you would please raise your right hand. Do you swear or affirm that you will, to the best of your ability, translate from ASL sign language to English and English to ASL sign language?
I
That's the only
will,
one
yes.
I have.
Thank you, ma'am, for joining us. And your name for the record?
My name is Rebecca, Rebekah. Last name Henze, Henze. I'm a nationally certified interpreter, level 3 in the state of Michigan, which permits me to have the endorsement for legal.
Thank you, ma'am, for joining us. Calling case number 210-44004, People of the State of Michigan versus David Lamar Banks. Counsel, your appearance for the record, please.
Philip Reagan on behalf of Mr. Banks. He waived the formal
Are you
reading,
wait-
stand mute. He has been advised of his constitutional rights, Judge.
Thank you. Court will waive the formal reading. Enter a not guilty plea on your client's behalf. Counsel, if you would please, can we jump ahead to your bond motion?
Sure, Judge. I'm asking for personal bond. My client is a lifelong resident of the city. Judge, he works, he used to work at a group home. He gets SSI. He lives with his sister. He does not live with the complaining witness, Tracy Phillips. Judge, the alleged location of this alleged incident was I-75 and Mac. Mr. Banks informed me that he was almost in a car accident on the expressway when he was trying to control the car. And Miss Phillips was accidentally hit, and they were trying to control some bleeding in her nose, but it was an accident. So when the troopers came, they tried to put him in handcuffs, and he asked them not to put them in handcuffs because he couldn't hear. That's how he talks, with his hands. So he wasn't able to communicate or say anything. So they just took him. So I'm hoping we can resolve this at the next pretrial date, Judge.
All right, thank you. DDC, as to bond, are there any holds?
No holds, Your Honor.
Well, counsel, the court appreciates your representations regarding your client, including your representations that he has long-term ties to the community. And the court also appreciates your emphasis on ensuring that Mr. Banks will have, in addition to legal representation, but also will have access to an interpreter at each stage of these proceedings. And the court will ensure that the minimus includes information that will travel with him, that he will need access to an ASL language interpreter. Court also balances that with the nature of the charges and the seriousness of the allegations, which are very serious, as they are allegations of a highly assaultive nature within the context of a domestic dynamic. And further, counsel, court does take into account your client's representations to your office with regard to the circumstances allegedly under which the complaining witness sustained her injuries. Be advised, counsel, and let the record reflect that your representations from your client run contrary to the information that is in the investigator's report. So the court simply wants to make you aware.
Thank you for that, Your Honor.
Of that. At the end of the day, the allegations include that despite, again, these differences that the court highlights above your client's representations to your office and that of the complainant, the complaining witness at the end of the day sustained a broken nose. Counsel, given everything that you have indicated on the record, the court is going to do the following. Let the record reflect there will be a pretrial date, January 25, 2021 at 8:30 a.m. at the 36th District Court in front of Judge Bryant. That's B-R-Y-A-N-T, Bryant.
I'm sorry, Judge Bryant or Judge Garrett? Because is this domestic violence? Bryant, okay.
Well, be advised, counsel, that on the paperwork that your client is going to receive, it indicates Judge Bryant, B-R-Y-A-N-T, Judge Bryant.
Okay.
Stand by.
Okay.
Oh, stand by. Oh, stand by. I'm sorry, counsel, you are correct. Thank you for bringing that out. You know what? In which case, this probably needs to be different as well. Stand by. Thank you, counsel, for highlighting that it is the case that this will be in front of Judge Austin Garrett, A-U-S-T-I-N, Garrett, G-A-R-R-E-T-T. Repeat for the record, this matter will be in front of Judge Austin Garrett, G-A-R-R-E-T-T. Thank you, counsel. Bond at this time will be the following. Bond is going to be in the dollar amount of $5,000 personal bond. More importantly, while this case is pending, your client will be subject to Wayne County Sheriff's GPS tether. Now, be advised, counsel, this court is balancing what the court has reviewed in the file with your representations and what was clearly the manifestation of physical injuries that laid the basis for the charge. So the court is looking to keep your client, to make sure that your client returns to court, that your client has an opportunity to have access to legal counsel and to be able to communicate effectively with counsel and aid in his own defense. But also, this court is mindful of the complaining witness and ensuring the complaining witness's safety. So that is the purpose for the bond, which will be personal bond, and the Wayne County Sheriff's GPS tether. Also, while this case is pending, Mr. Banks is to have absolutely no contact with the complaining witness, Tracy Phillips. No contact means no written or verbal communication with this person, no messages to her through third parties. The no contact order also extends to her place of residence and place of employment, and no social media contacts directly or indirectly. The most important thing about this case is the no contact order, because if Mr. Reagan, if your client violates that no contact order in any way, shape, or form, he will be picked up and he will spend the rest of this case in custody. Now, again, this court is mindful and cognizant of Mr. Banks's need to be able to avail himself of the best opportunities to communicate with counsel. But if he gets picked up because he's violated the no contact order, he's going to spend the rest of this case in custody. And if it is uncomfortable or if it takes everyone to great pains for him to be in custody under these circumstances, given that he will need the opportunity to communicate effectively, then he will be mindful. He's in the driver's seat on this. Because if he ignores this court's order and violates the no contact provision, he's going to get picked up. And he's going to spend the rest of his case in custody. No access to an immediate interpreter, and he's going to be on his own until he gets until he can have access to an interpreter. So if he values his liberty, he'll have no contact with that complaining witness, Ms. Phillips. Is that clear?
Yes, Your Honor. Yes, Your Honor.
Madam Interpreter, just to clarify, the gentleman is answering in the affirmative. Is that correct?
Yes, Your Honor. I was just getting ready to tell you that Mr. Banks has conferred that he does understand what I have signed to him, and he understands that he has to have no contact with Ms. Phillips.
Thank you very much, madam. We appreciate your assistance with this.
What does?
Yes, ma'am.
I'm sorry. He's signing. He said, "Say it again, please. Repeat it." Okay, what? What if she contacts me on my phone?
Then you do not pick up the phone. You do not respond to any messages from this person, because now that this is a criminal matter, that you are now under orders to have no contact with this individual. Even better, if she does contact you, it would be prudent for you to simply keep a record to yourself of any instances where this person has made contact with you and share that information with your attorney. But under no circumstances are you to respond, because you are under a court order right now to have no contact. So that frees you from that burden. Do not feel guilty. This is for your liberty. Otherwise, you risk getting picked up and you're going to spend the rest of this case in custody. Do you understand?
Yes, okay. Okay.
Thank you, madam. Thank you for the question. Counsel Reagan, is there anything further?
Nothing further, Your Honor. Thank you very much.
Okay, Madam Interpreter, thank you very much. We appreciate your time. We're finishing. Stand by.
I'm sorry, Your Honor. One more thing. You had told me
yes, ma'am.
A tether, and he is not familiar with that process.
The Wayne County Sheriff's deputies will be in contact with him, and they will talk to him and give him information about the tether program. And also, you just reminded me as well to ensure that his paperwork includes needs an ASL interpreter.
Does the tether mean I have to stay home?
You will have, if you are working or if you have doctor's appointments, you are allowed to do that. But the tether is more to ensure that you are not in contact with Tracy Phillips. So it's more based on location, not a time limit, just that you cannot be near Tracy Phillips or near her home. Do you understand?
Yes, I understand. Very clear.
Okay, Madam Interpreter, before we let you go, just make sure if Mr. Banks has any other questions or anything else that he needs clarified.
He says, no, I'm good. Thank you. Thumbs up.
Okay, thank you, Madam, very much. We appreciate you and your time. I think that completes everything. Counsel, is there anything, Counsel Reagan, is there anything further before we are done with Madam Interpreter services for the day?
Nothing further, Your Honor.
Okay, Madam, thank you very much for your time. We are concluded. You can tell the gentleman that he can step away from the camera, and we're going to make sure he gets his paperwork.
All right, great. Thank you.
Thank you, ma'am. Thank you. We are concluded.
Thank you.
Okay, Council Reagan, I think also Mr. Watts. For
Yes,
you,
Your
is
Honor.
that correct? Okay. Okay, your name for the record, sir?
Brandon Watts.
Okay, calling case number 2006-2663, People Say Michigan versus Brandon Anthony Watts. Watts, come to your appearance, please.
Your Honor, Philip Reagan on behalf of Mr. Watts, waive the reading, stand mute. Mr. Watts has been advised of his constitutional rights, Your Honor.
Court will waive the formal reading and turn not guilty plea on your client's behalf. Counsel, let's move forward to your bond argument, please.
Thank you, Judge. My client, Judge, is 30 years of age, lifetime resident of this city, Judge. To my knowledge, has no prior criminal convictions. He has, he's not working right now, Your Honor, but he has completed some college, has a GED, did go to WC3. He's currently on probation or parole at this time, Your Honor. Judge, the complaining witness is a Daniqua Sears. My understanding that, you know, they are on good terms now, right now, Your Honor. And Judge, you know, I have to be forthright with the court. My client is currently awaiting a pretrial date, Judge. So, Judge, what happened was back on September
pretrial date
7th,
for what, counsel?
for domestic violence, Judge, Ms. Seals. So let me tell you the basis of all this.
Okay, I'm sorry. Okay, this is a different case aside from the one before the court today?
It is, Judge, and I want to be forthright with the court, Your Honor, based on the everything that's happening. So back in September, someone calls the police. Someone calls the police, not Ms. Seals, is my understanding, and my client gets arrested for domestic violence. So, in fact, there's a capious issue on September the 14th. I'm sorry, October 14th. I don't know if you can hear me, Judge.
Okay, I'm sorry. DDC?
I got you, Your Honor.
Okay, I'm sorry. It's just that, it's just the background information is affecting our audio.
Yes.
Okay, thank you, ma'am. Okay, counsel, go ahead, sir.
Judge, so on October the 14th, he had a pretrial date scheduled. So at that time, someone else had called the police. So on October 14th, he zooms in, Judge. They tell him to go to the hospital. He goes to the hospital because he has chest pains. Somehow a warrant got put out for him on October 14th.
Okay, I'm sorry, counsel. I don't want to interrupt your narrative. Just to clarify, you said he zooms in, meaning that he was out of custody?
Correct. He had a $5,000 personal bond back on September 21st. He got a $5,000 personal bond for the domestic violence case with Ms. Seals. He zooms in for his pretrial date on the 14th of October, gets sick. Somehow they tell him to go to the hospital. Somehow he gets a capious put out on him.
They who?
The attorney, correct? And who told you to leave me?
My attorney that I had at the time, she was telling me that it was a whole bunch of stuff going on. I couldn't breathe. She was like, go and rush to the emergency because I needed an inhaler. But then my mom had called me and told me, like, they're looking for you still. And then I was like, well, I'm at the emergency now. And then I got a warrant put out for my arrest, and I found that I had a warrant put out for my arrest. I went to jail in December just now. And
hold on, let me get to that. Let me get to that part. So that was on October 14th. Somehow, Judge, on October the 17th, when this case was allegedly initiated, October 17th, 3 days later, my client said someone else, again, I guess, called the police because he knew nothing about it. So he's been with Ms. Seals from October 17th up until December the 21st. December the 21st, Your Honor, he was arraigned. He was arraigned on the capious from that first case, okay, December 21st. He was given a personal bond again and given a pretrial date of January 9th. Somehow the Wayne County prosecutor must have got wind and he was locked up because they didn't sign the warrant on this case until the very next day, December the 22nd. So he had been with Ms. Seals. There's no issue with Ms. Seals. And he said someone else is calling the police. So it was 2 whole months before this warrant even got signed. And in fact, it was the day after he was in custody again that they decided to sign this warrant. They weren't going to sign the warrant, it looks like, until he got in custody on the capious, Judge. That makes sense based on how the warrant was signed. So now I just want to be forthright with the court. He told me today him and Ms. Seals have no issues, but I understand. I told him, I said, it really doesn't matter because of the allegations that you have to look at. So he's going to have no contact with her. But again, Judge, he has no convictions, no prior convictions, says that he and Ms. Seals are on good terms right now. And there's no issue. And I found it kind of strange at the timing of the signing of the warrant. Again, it was the day after he was back in custody. And again, both times, Judge, he told me that Miss Seals did not call the police. So for that reason, Judge, I understand he would probably need a GPS tether, but I'm asking the court for a personal bond and no contact, obviously, because now you have 2 cases and it doesn't matter what she really wants. She needs to come to court and she needs to stay, what she really wants, Your Honor. So no contact would be the provision. I'm asking for a personal bond with the tether, but I wanted to be forthright with the court about the circumstances that were leading up to this.
Well, counsel, the court appreciates your representations and the court also appreciates your candor with regard to explaining the sequence of events. But with regard to the case before this court at this time, and the court, based on your emphasis on someone other than the complainant, made contact with the authorities that essentially brought the officers to that location on October 17. Or just be aware that the record reflect a review of the file suggests that despite your client's representations, it appears that the complaining witness, Ms. Seals, was not endorsing his presence at that location despite your representations or whatever it is that your client has represented to you about the sequence of events. Specifically, that if it is the case that everything was on such good terms based on a review of this file that suggests that your client gained access to that location and it was not with the complaining witness's consent. Further, that he gained access to that location. Hang on. Specifically on the date of this alleged incident, when she arrived at the home, your client was already in the home. There was damage to property in the home. Property was missing. And further, that there was an alleged physical assault. And the last substantive sentence is that the victim stated she did not give the offender, Brandon Watts, written or verbal permission to be inside her residence. He had gained entry into the location from the side window of her bedroom. That does not suggest that everything was on such good terms and that your client was, or rather, it's almost a statement by omission that he was in the property, but not necessarily with the complaining witness's consent. So his representations to you and subsequently your office's representations to this court that he was there as of XYZ period of time leading up to this incident suggests, yes, that may be true, but perhaps not with her consent. That's based on a review of this, or what's before the court today.
And Judge, I do understand what the court has read. And Judge, all I can say is that, Judge, I believe half of what I see and none of what I read. I just watched a man this weekend spend 4 days in jail because the police could not read a simple PPO. Now, Judge, all I can say to the court is it doesn't take 2 months to sign a warrant for home invasion. If this allegedly happened on 10/17, why did they not sign the warrant until 10/22, the day after he turned himself in on 10/21? It doesn't take rocket science for the police department, Judge, to figure it out. And I think, Judge, that's one of the reasons why I kind of looked into it and I asked him about the circumstances, because it doesn't take 2 months to sign a warrant. If he was there against her will, they could sign that right away, boom. But it was something that they didn't have to sign for whatever reason and waited until he got back in custody and somebody said, hey, let's put this warrant through. That's why what he said to me made sense, Your Honor. That's the only reason why I kind of represented to the court, because it didn't make sense the other way. But I do understand the court's position, Judge. You have to go by what you're reading and what you're presented with, and that's what it says in the investigative report. So I do understand the court's position, Judge. I just asked the court to take consideration on the length of time it took for the prosecutor to actually sign the warrant when this alleged incident occurred back on October 17th.
All right, counsel, let's jump ahead a bit, because the next question is going to be, because bottom line, there's going to be a no contact provision while this case is pending. So your client, from this day, this moment forward, he's going to be as clear as he possibly can be. No confusion about what he should or should not be doing from this moment forward. So does your client have someplace else to be while this case is pending?
Judge, he says he can stay with his aunt. He can stay with his aunt, Judge. It will not be near Ms. Seals. And I told him, Judge, I said, even if someone else called the police, that's 2 times. I mean, something is going wrong with this relationship, this situation. He needs to take himself away from it. They don't have any kids together. There's no reason for you to be there, period. There's no reason. Nope.
Mr. Watts, you need to be very thankful that your client is that your attorney is going to bat for you, because this court has some real concerns that it has articulated on the record, because this court has a real concern about ensuring not only your safety, but that of the complaining witness, because if things are that confusing, or if there is that much amount of concern surrounding the two of you being in each other's presence, that tells you that you need to remove yourself from the situation. So this court's going to make it very, very simple. Are you ready? You need to listen.
Yes, ma'am. Yes, ma'am.
Let the record reflect there's going to be a Zoom probable cause conference date February 1, 2021 at 8:30 a.m. to 36th District Court, followed by a Zoom preliminary examination date to be determined, and it will be in front of Judge Archer. Further, at this time, court is going to set bond in the amount of $10,000 personal bond, and the gentleman will be subject to Wayne County Sheriff's GPS tether. Further, while this case is pending, sir, you are to have no contact whatsoever with the complaining witness, Deniquia Seals. Do you understand, yes or no?
Yes, ma'am.
No contact means no written or verbal communication with this person, no messages to her through third parties. The no contact order also extends to her place of residence and her place of employment. Do you understand?
Yes, ma'am.
So it does not matter if the complaining witness contacts you, calls you, begs you, shows up on your doorstep, sends you flowers, puts love notes on your window. You do not contact this person. You do not go back to that place of residence. Do you understand?
Yes, ma'am.
Counsel, is there anything further that we need to cover?
No, Judge, you covered everything. It's over. That's it. No more. It's done. That is his best interest, and we've gone over that, period. So he's the one sitting in jail right now. So he has to understand that that's it. It's over with.
The court wants to clear up any confusion or any concerns that anybody may have. So this is the last opportunity, because whatever it is that's going on with the other case, this court doesn't have that in front of it right now. So the presumption is that if it's involving an assaultive case with the same complaining witness, the presumption is that the judge or magistrate, whoever did the arraignment of the other case, said no contact. And for whatever reason, somebody got terribly confused about what no contact means. So guess what? Today, right now, from this moment forward, it's on the record. The three of us have had this conversation, which means, sir, that if we see you again and you see this face right here, you know that I know we had this conversation. Do you understand?
Yes, ma'am.
Because any indication from you to this court that you were somehow confused and you did not understand, all bets are off. Do you understand?
Yes, ma'am.
Counsel, is there anything further?
Nothing further. Thank you very much, Your Honor.
Sir, you're all set. You can step away from the camera. Okay. Okay. We'll see you on the women's side, madam.
All right.
Thank you. Okay. Okay.
I'm so sorry.
Sorry. Sorry. In a weird way, that might be the nicest thing you've ever said to me. Oh, boy.
Your Honor, number 2 on the list, Norwood Ellis. You did understand the fee, we just spoke to him, and he's gonna do it.
Thank you so much. Thank you. Oh, I think, okay, I think that's this person now is running it. Hi, ma'am, your name?
Oh, yeah, don't take it off ever. Thank you.
Okay.
Thank you.
Hi, ma'am, your name?
Tierra Norwood Ellis.
Okay, and it's just the case that your attorney just dialed in. So, counsel, can you hear us? Are you ready?
I can, Your Honor. Yes.
Thank
good
you, sir.
afternoon. May I please-
Okay, stand by. Let me call the case. Calling case number 206-2639, People State of Michigan versus Tierra Norwood Ellis. Counsel, your appearance for the record and your P number, please.
Yes, Your Honor. Thank you. May I please the court, Tyrone Bickert, P number 62647, Norwood Ellis. Your Honor, I would apologize for my appearance, Your Honor. I did not expect Miss Norwood Ellis, who was just picked up, to be arraigned this afternoon. So I do apologize for my apparel.
No, it's fine. Thank you, sir. We appreciate you, and we appreciate that you were able to make it. You were able to join us. You're waiving the formal reading, saying your client mute.
Certainly, Your Honor. Yes.
Okay, thank you. Call waive the formal reading. I'm sorry. Go ahead, sir. Well, call waive the formal reading. Enter not guilty plea on your client's behalf. It's going to be a Zoom standby. Court's going to review the file briefly.
Understood.
Okay, counsel, if you would please, before we do the court dates, can we jump ahead to your bond argument, please?
Yes, Your Honor. Simply put, Your Honor, this is a case that I believe that is a reissue, I believe, of a case that was dismissed due to the complainant not appearing, Your Honor. Ms. Norwood Ellis has always been in contact with me regarding the situation. She did appear at several Zoom court hearings, and subsequently the case was dismissed. I believe that this is a vindictive situation between her and the complainant, where he chose to go to the prosecutor's office to try to get a reissue and was in fact successful in doing so. But given the fact that Ms. Norwood Ellis has always participated and shown up and has retained counsel for the case, Your Honor, I would strongly ask the court to consider a personal bond for her. I can assure the court that she can appear as she always has in the past.
Thank you, counsel, for your representations and also for the background information leading up to today, the instant, the arraignment on the instant case today. Counsel, just to clarify, and you did indicate, and the court appreciates you pointing out that this was back an alleged matter from August of 2020. The court also, in noting the investigator's report, shows that at least at the time of this alleged incident, the location of the alleged offense was the same as that of the complaining witness, and same as that of your client. What are the current arrangements now? Are they residing together, or is your client, because there is going to be a no contact order regardless, so is she someplace else other than the alleged location of the offense?
Your Honor, at that time, it's my understanding that they were living together. However, Ms. Norwood Ellis has sent, it's her house. She and the complainant have separated. She had left the house. In fact, Ms. Norwood Ellis has a PPO, an active PPO against the complainant as we speak, Your Honor.
Okay, so again, just a simple yes or no, they do not reside together. Is that correct?
Do not. No, they do not.
Thank you. All right, counsel, here's what we're going to do. Court will waive the formal reading into not guilty plea on your client's behalf. There's a Zoom probable cause conference date February 1, 2021 at 8:30 a.m. to 36th District Court, followed by a plenary examination date also by Zoom at a date to be determined at the 36th District Court in front of Judge Archer. And you've made your bond argument. The court appreciates that. Given your representations, court will do the following, and particularly that you've indicated clearly on the record that the parties no longer reside together, because there is going to be a no contact order while this case is pending. Given those elements, court on this case will set bond the amount of $7,500 personal bond while this case is pending. No contact with the complaining witness, Anthony Morgan. No contact means no written or verbal communication with this person, no messages to him to third parties, and no contact order also extends to his place of residence and place of employment, and no social media contacts directly or indirectly. Is there anything further, counsel?
No, Your Honor. Thank you.
Okay, thank you very much. Thanks for your time, sir. We are concluded.
Thank you.
Yes, sir. Okay, DDC, we're done with the retained case. We can we can take care of Jennings when you're ready.
Step in. Happy New Year. Good afternoon. Good evening. How you doing?
Happy New Year, ma'am. Doing well, ma'am. Your name, ma'am?
Chester Jennings.
Okay, calling case number 210. Thank you, ma'am. Calling case number 210-55055, People State Michigan versus Chestina Samantha Jennings, counsel.
Brian Morales, on behalf of Ms. Chestina Jennings, we will reading and you concerns the advice for constitutional rights.
Okay, court will waive the formal reading, enter not guilty plea on your client's behalf. Stand by. Stand by. Okay, counsel, before we set dates, if we can jump ahead to the bond argument, please.
Yes, thank you. Your Honor, Ms. Jennings is a 32-year-old lifetime resident who is destroyed. She wants the court to know that she has 5 minor children, all ranging between the ages of 3 and 15 years old. It does appear that she does have a felony conviction for 2018, Your Honor, but there's no assault history whatsoever. I'm unaware of any habeas history. Unfortunately, she does suffer from seizures right now. She was being deployed, did have surgery, is now needing care on the side to provide for her and her 5 children. Most importantly, Your Honor, understands no contact with the it never appeared that the complaining witness was the girlfriend of one of Ms. Jennings' roommates. That was the complaining witness based on that conversation. Ms. Jennings, based on our officer's conversation with Ms. Jennings, does not reside at the Grand Boulevard address. Ms. Jennings has posted contact with some of her friends to help mount the defense on her behalf. We really wanted her to get some of her treatment that she needs because of her seizures and other issues going on in her life. Further, Your Honor, we ask this court respectfully to consider a personal bond in this matter with a no contact. I also ask the court not to hold the chief just because she does not make any money, Your Honor. I do not believe her ability to pay would be sufficient to afford a GPS tether. I'd ask the court to treat Ms. Jennings as her local relationship and release her under the documents for file.
Thank you, sir. DDC is bond, any hold?
No holds on the sheet, Your Honor.
Thank you, ma'am. Council Court takes and counter representations. Here's what we're going to do. Let the record reflect the court will waive the formal reading, enter not guilty plea on your client's behalf. There's a Zoom public cause conference date, February 1, 2021, at 8:30 a.m. at the 36th District Court, followed by a Zoom preliminary examination date and a date and time to be determined at the 36th District Court. It will be in front of Judge Jones. You've made your bond argument. Court is going to do the following. Court is balancing your representations, including her ability to pay. Also, court is balancing the extra element facing the country with regard to the COVID and COVID protocols and safety to your client while this case is pending. Further, you've indicated that it appears that the complaining witness does not reside at the same location where this alleged offense occurred, and also that way she'll be able to return home to her family. And she has stable ties and residence in the community. Given those elements, court will set bond in the amount of $5,000 personal bond, and no contact with the complaining witness, Tiffany Gardner. No contact means no written or verbal communication with this person, no messages to her through third parties. The no contact order also extends to her place of residence and place of employment, and no social media contacts directly or indirectly. Further, Ms. Jennings, be advised, and please listen, no contact means that the responsibility is yours. If for some reason that complaining witness or that person shows up at that residence, it is your responsibility to remove yourself from that situation or make sure that you are no place in the area where that complaining witness is located. Now, if it's the case that it's a two-family flat or you and your roommate share space, if you have space where you can be by yourself or be off by yourself, you need to remove yourself from the situation, close yourself away in a room, or if you see that person coming down the street, it's your responsibility to turn around and go in the other direction. Do you understand?
Yes, ma'am.
Okay, and any changes to that or any of those conditions, please, okay, so any changes to that or those conditions of bond is up to a judge at the next court date, so you're in the driver's seat on whether or not you'll be able to stay in your home. But again, no contact with the complaining witness. Do you understand? Okay, counsel, anything further?
Nothing further.
Okay, we're concluded. DDC, thank you. Is there anyone who's been with you for 48 hours or more?
Not to my knowledge, Your Honor.
Thank you, ma'am. See you next time.
See
Yes,
ya.
ma'am. Well.